Some professors spend a lot of time on Purposeful Availment and jurisdictional analysis as it existed prior to international shoe in their first year civil procedure course. Much of it doesn't apply anymore, and as a result, gives a lot of students a lot of trouble trying to understand what's going on. And I'm going to try to clear up a little bit of what's left of Purposeful Availment after international shoe. But before we get there, I want to go over some definitions. One, in personam jurisdiction. It's basically what we've been talking about until now. This is the traditional jurisdiction over the person. It means basically what it sounds like. Two, in rem jurisdiction, or perhaps more accurately, quasi in rem type 1 jurisdiction, is jurisdiction to sue someone over a piece of land. A typical example is going to be a foreclosure action. Quasi in rem jurisdiction, or more accurately, quasi in rem type 2 jurisdiction, is the old doctrine that international shoe basically got rid of. It used to be that if someone owned a piece of land in a state, you could sue that person in that state for basically any reason, regardless of minimum contacts, and making a claim directly on the property for its value, rather than on the person himself. Now, quasi in rem jurisdiction, or quasi in rem type 2, still has some applications. Most of them are likely beyond the scope of your course, but we will discuss one example when we get to the long-arm statutes. In addition to discussing quasi in rem jurisdiction, Pennoyer specified 3 historical bases of jurisdiction: presence, consent, and domicile. All 3 remain relevant, and that is really what you have to know from Pennoyer v. Neff. Aside from the exception to the rule that we're going to talk about in the context of long-arm statutes, presence, consent, and domicile are the 3 big issues that remain. Physical presence in a state will often create a basis for personal jurisdiction. The Burnham case involved a New Jersey resident who went to California on business to visit children. He was sued while there and argued that there were no minimum contacts in the state of California. The Supreme Court upheld the jurisdiction on the basis of his physical presence at the time of service of process. Being present was enough. Now, there are 2 basic approaches to understanding how Burnham works. Some have argued that minimum contacts and personal availment just simply go out the window when physical presence exists. You don't need to consider minimum contacts and personal availment if the person is physically there. The other approach, and probably the one you're going to want to take on your exam if you can, because it'll give you the opportunity to discuss minimum contacts and personal availment, is that the fact that the person is physically present means that he is taking advantage of the benefits of the state, and therefore has personal availment almost by definition. Being there is itself the personal availment. The difference between these 2 approaches is the rare case where physical presence is so auxiliary, so temporary, that it cannot plausibly give rise to personal availment. For example, if you're in a plane flying from state A to state F, and on the way pass over B, C, D, and E, but while in E, you're just nipping the corner really of state E, you're there for all of 5 minutes, somebody comes over to you, happens to be the plaintiff's process servicer, and gives you a bunch of documents informing you that you have to appear in court in that state. You're only in state E for all of 5 minutes, I should say. It's really rather auxiliary to your trip. You have no contacts there. You have no business there. Your personal availment while in that state is quite limited, but you are physically there. Whether jurisdiction would exist under those very strange facts is unsettled. Number 2 is domicile. Domicile is also sufficient if you live in a state, even if you're not physically present at the time. You have contacts with that state and have personally availed itself of its laws. So of course jurisdiction exists. It's really just a subset of the general rule. But what you have to know about domicile is that each person has one and exactly one domicile. If he has 2 houses in different states, his domicile is the one that he intends to be his permanent residence. That means if I have a summer home in Miami, I'm not necessarily a domicile of the state of Florida. My domicile is where my permanent residence lives. Having a house in Miami might give rise to personal availment in the state of Florida, but that's a separate analysis. Number 3 is consent. Consent provides jurisdiction and comes up in a few ways. Number 1 is explicit waiver. Remember that the rules of personal jurisdiction are there to protect the defendant, and if the defendant doesn't want them, he can waive them. Number 2, failure to timely object or to follow state procedures. Failing to complain about personal jurisdiction, or sometimes to not do so in the way the state requires, implies consent to the suit, thus barring further objections to personal jurisdiction. Number 3, being the plaintiff. If you sue someone in a state, you have consented to counterclaims in that lawsuit, regardless of the fact that you have no contacts in that state. The plaintiff is always subject to attack in the same suit in that state. Number 4, assigning someone to accept service. Some courts have said that a business that assigns a person to accept service on its behalf in that particular state consents to jurisdiction in that state. However, be careful. Consent cannot be coerced. And in many states, if you do business in that state, you have to assign someone to accept service. In those states, if you have to assign someone, the fact that you have to assign it implies that you're being coerced to, and your coercion cannot plausibly be deemed as consent.